Good afternoon everyone, and welcome to this week's sessions with Sarah. So every week we're looking to do a quick 10-minute video on different topics to do with family law, although I am open to suggestions. So please feel free to put any suggestions or inbox our page and we can look at that next time. But this week we're discussing superannuation and family law. Now this is a pretty important topic because in many relationships superannuation is one of the biggest assets, or if not the biggest asset. So it's really important that it's included in any split and parties understand what their obligations are and what they may be entitled to under the split. So why is it so important? Not just because it's large, but also because it's someone's retirement benefits in the future. So without superannuation, you're relying on the aged care pension, which can be a lot less than super, or this can help supplement your aged care pension in the future. So the main thing to know about super is, and what people often ask us, is what am I entitled to? Because often we have the situation where we have, maybe let's say for example a 20-year relationship, husband and wife, husband has worked throughout the whole relationship and wife hasn't because she's taken time off to raise the kids. Therefore the husband spent 20 years putting his super up and up and up and lots of money going in there, and the wife hasn't had that opportunity. She might have, let's say for this example, she has $50,000 of super. He has $200,000 worth of super. So quite a substantial difference in what they could receive. And so what we often look to do is make sure the parties end up on that fair and just and equitable outcome, which is what the courts are looking to do. So whether it's super or whether it's any other asset, what the court wants is for people to have a just and equitable outcome. Doesn't mean it's always a simple answer, but it's really just trying to make sure that both parties come out on somewhat level footing. So let's use our example of husband and wife. In 20 years, you can probably expect what's called an equalisation of superannuation. Thanks, Kath, for the question. Does the super you get in your divorce have to be put into a super fund, or can you use it for other things? That's a very good question, and it depends on your age. So I'll get to that in a minute. I guess the brief answer is if you're above the age of 65 or whatever your drawing age is for the super fund, you do have the potential to draw it out in cash. But an important function of how super splits work is that it's split from one super fund to another. So it stays as super no matter how it is split. Although we have had circumstances where the parties have been above the age of 65 and instead of getting a super payout to one party, if, for example, the husband has drawn an amount of $100,000 out of his super account and given it straight in cash to the wife instead. So yes, going back to our husband and wife example, we have, the wife's only got $50,000, the husband's got $200,000 of super. There's a $150,000 difference. So what we'd want to do in the circumstances of an equalisation is make sure that they have an equal amount of super. So in that one, we've got 250 odd thousand of super all up. So we want each party to have about 125,000. In that instance then, that means that the wife's $75,000 short of that. I'm sorry, I'm doing maths on the fly, which means that we're giving her $75,000 of the husband's super. So his goes down from 200,000 to 125,000, and the wife goes up from 50,000 up to 125,000. So they're both on the same level. Doesn't mean that an equalisation is always the correct answer. There can be other circumstances in play. So for example, in a circumstance where a wife, for example, a wife doesn't have the ability to earn the same income as a husband, therefore her super entitlements will never grow to the same amount that his will. We might look at giving her more super than the husband. Another important factor is what the parties get outside just the superannuation split, so what sort of cash and assets they're splitting as well. So it's not unheard of for a party to choose to take more of cash assets and no superannuation, or vice versa, and only take superannuation and not cash assets. It really is dependent on the couple and what they want to do and what's going to work for someone. And then going back to how we actually affect a split, super funds need what's called procedural fairness because they become bound by any agreement made. So if we're getting a court order, we have to give them 8 days notice of what we want to do before we can actually apply for that court order, and then they're actually bound by it. And this circles back to Kath's question earlier. So in many circumstances, we're asking the super fund to affect the order, meaning that the super fund is actually going to transfer the money from person A's accounts to the second person's account. So it still stays as super. Although, like I said, it's not unheard of if parties are above the preservation age in their super fund to decide to withdraw a lump sum of cash and pay it to the other party. And once that super is split into your account, it still functions like super. So if you're only 30 years old, you still need to wait till your preservation age until you can touch it, but you do get the benefits of any interest or anything going in over that time frame. Another important thing to consider is the way the super is structured. So in many circumstances, it's an accumulation fund, which is basically cash in the bank for all intents and purposes, as opposed to what many army people have is a DFRDB, or a defined benefit scheme, and this means that it is never a lump sum, but it's only a pension you can draw on. So another important aspect of doing a superannuation split is to make sure you get the financial advice in what is going to work out best for you. And my phone is running out of battery, so I think we're going to have to wrap it up there. But like I said, any questions can be directed to our page or our admin email, and we're happy to take them. Also taking suggestions for next month's session with Sarah. But thank you very much for joining.